Hello, everybody. So the four of us up here do a lot of work representing nursing home residents and their families. So we're going to talk a little bit about that subject and a little bit about the lessons we learn from nursing home work that's applicable to all kinds of personal injury and wrongful death cases. How many here of you are lawyers? So I'm going to try to generalize this talk a little bit more than I normally would to include the non-lawyers in the room. A little known fact, or maybe you do know this, is that although we are trial lawyers and we specialize in trying cases, well over 95% of all cases filed in the Circuit Court of Cook County are resolved without an actual trial. So that means that any lawyer that's working in Cook County needs to be aware of achieving a maximum result for their client without a trial. And that process is typically called mediation or negotiation or pretrials. So if I have 100 cases that I'm representing 100 people in my law firm, 95% of those cases will be settled. So what I'm going to talk to you about is how we have developed certain ways, and this can apply to any type of negotiations any of you do, to maximize the value of the case for our client. So when we go to a mediation, and a mediation typically there's a pretrial means there's lawyers and clients on one side, the insurance companies and the corporations and their lawyers are on the other side, and there's a neutral individual whose job is to try to resolve the case. And typically we meet together, then we meet separately, and they go back and forth until the case either is not resolved or it's resolved for a dollar sum that everyone is happy with. So we look at this process in a much different way. When a client hires us, they're hiring us for two reasons. Number one, to hold the wrongdoers, hold the people that injured or killed or maimed them or their relative accountable. And the only way we can do that in our system is by a dollar amount. What is fair and reasonable for the harm that occurred to our clients? So when we go into a mediation, you've all probably heard of the concept of getting to yes, where you go to the mediation and everyone comes out happy and you solve all your problems. That's not what we do in our work. Our job for our clients on the plaintiff side is to achieve the most amount of money that we can. So one of the things we like to say, and Margaret, I think we have this slide, is it's not about feelings. If someone is sad or distressed over what happened to their loved one, that's something they should take up with their family, their clergymen, or whoever else they go for comfort. Our job is to get the most amount of money. What that really means because what we're doing is not getting to yes, we're doing a form of bargaining called distributive bargaining. That means every cent we achieve for our client is every cent the other side is paying and vice versa. And it's a zero-sum game. So it's not about our client's feelings. So when the negotiator or the mediator says, at the end of this process, I could all make you feel a little better, I say, that's not your job. That's somebody else's job. Your job is to help us achieve the maximum recovery that we can for our client. And that gives you a different mindset. Because what often happens is, when it's about feelings, the mediator starts talking to our client, and our client, who is not a regular in the system like the other side, pours their heart out. And what they're really doing, in my opinion, in a nice way, they're not evilly doing this, is they're beating our client down. They're allowing our client to feel emotion. and that results in our client forming a mindset that would make them more inclined to take less money than they're entitled to. So number one rule when you mediate in a zero-sum type game is it's not about feelings. It's about achieving the maximum result. You know, if it's a business deal and you're going to do business again in the future, you may have to approach these in different ways. But we're representing individuals who have one case. The other side, our opponents, the insurance companies and the hospitals, have many cases. So in their view, they're looking at it differently. But we only have one client who has one case and one shot in court, and it's our job to get the maximum amount of money for that client because that's all we can do. So that's one rule. Now, of course, when I say this to the mediators, they immediately hate me. Everyone in the room hates me. Sometimes my own client feels that I'm becoming too aggressive, but after a while, I think they understand the concept of what we do.
It's not about the other side's feelings.
Right. It's also not about their feelings. Oh, they're upset with you. Oh, they think you're negotiating in bad faith. Oh, they're doing this. Oh, they're doing that. I don't care. It's what we do. We either resolve the case in a fair way or we don't. The second rule that we try to follow is we are selling a release. We have sued someone for a wrong that has harmed us, that maybe has killed us, and they want to get peace. And the only way they can get peace if they buy our release. Now, we don't go in there and say we're selling a release, although we did have an incident when I was explaining this mindset to one of our younger lawyers, and he went to a pre-trial and he starts telling the judge that we're selling releases, and she called me on the phone and said, "What is going on? I don't even know what he's talking about." But the concept is we're not there for them to give us something, for there to give us money or to give us charity. That's what they want to say. We are there to sell something. If we set a fair price for it, our client has already paid dearly for that, and then it's up to them to buy it from us if they choose. Again, that's the mindset that we go into when we do these type of things. And another thing you have to do, when you go into these mediation, you need to recognize, this is a slide, Margaret, unequal bargaining power. I am there with my client. We have 100% authority to settle the case. The other side may not come there with the person who has the ultimate authority to settle the case. So the other side may have 3 layers. There's a defense attorney. There's the line insurance adjuster. There's someone in the home office. And all those people come to this mediation with preset numbers. So if, let's just say, I'll make up a number, the case is worth $1 million, we think, they may send someone there who has $300,000 authority. So no matter what I do, no matter what I prepare, a lot of people talk about the importance of what you prepare in the mediation. It doesn't matter if that person has $300,000 in authority. So, and if that person has that preset authority, and this is not accidental, there's layers to wear the plaintiff side of the people down. If that person has $300,000, they're not going to give it up in the first 10 minutes. So you could spend a day trying to get to where you need to get all their authority, and it won't be enough to settle the case. So we like to, it's not always successful, say, if we're demanding $1 million, we want someone at that mediation who can pay $1 million. I'm not saying they have to, but they have to have the authority to do that. Otherwise, it's not a negotiation. A second thing you have to realize when you're on our side is that plaintiffs, and sometimes plaintiffs' attorneys, are risk adverse. Let's assume a case is worth $500,000, and they offer, after the process goes back and forth, $200,000. And you know that they're not going to pay what we've advised our client the case is worth. So now our client, because they're a citizen, they're a lay person, they're not in this system, they don't have 100 cases like the insurance company have, they begin to think if they leave, they're going to walk away for $200,000. So they're going to think about maybe they should sell something worth $500,000 for $200,000 because of the pressure of the proceeding. I came to this, I mean, this is written about phenomenon, but it occurred to me once where I bought a stock, an internet stock, for $10 in an IPO. And then all of a sudden it's at $90. And I have no reason in heck to sell this stock. I should keep it for the rest of my life. The person I bought it with starts telling me, $90 seems like a little high. So now I'm watching the stock every day. And if it goes down $1, I think I've lost money. And I get myself in such a state that I sell the stock. So that's what happens to our clients. Because they're not regulars, because they're risk adverse, because the process is an unnatural process where they're getting money for harm or death, they get weakened. So you have to recognize that bargaining power. You also have to recognize that many of the people on the other side have a pool of money that they're trying to distribute over time. Call it a claim period. And if they can't get it to you, they'll go on to the next person. And that gives them an advantage. And sometimes they, if let's assume a company has a $10 million claim in a certain period of time. Well, they may first go in and try to knock out the easy claims, the people that want to settle quick for less money. Then they'll go to another level, and then they'll go to another level. And oftentimes, when you get to the lawyers who really try the cases, then you start talking about real money, but they've knocked out a lot of claims. So that's another thing that you need to be aware of. Another principle of mediation is, at least how we do it, is past results do not predict the future. So if people say, well, all these cases settled for X amount of dollars 4 years ago, that in no way is predictive of what a jury will do on the case that's before the mediator. It's not even relevant to it. It's what a bunch of lawyers did in the past to transact business to resolve case. So 5 years ago, 10 lawyers settled a case, like a back case they call it, but there's no such thing as a back case. Each of our clients have a story. Each of our clients have suffered. Each of our clients have different considerations. So when they start telling you, well, this case settled this amount of time for this money, it's a meaningless number. Or sometimes you go to counties outside of Illinois and they'll say, no jury verdict has ever been more than X in this county. Then you say, well, have many of these cases ever been tried in this county? No. Or maybe 3 cases have been tried in this county with all kinds of, so past settlements do not predict future results. You have to evaluate your own case on what you think it's worth at the time you have it, at the time it's going to be tried. Past jury verdicts don't predict future jury verdicts. Think of the variables for you scientists out there. You could not do an evidence-based study to compare a jury trial 2 years ago in God knows where to what's going to happen tomorrow in Cook County. You have different lawyers, you have different clients, you have different facts, you have different liability, you have different witnesses. There's so many variables that it's really an irrelevant factor. So don't ever, if you're in this situation, be swayed by what has happened in the past. Other thing you have to do is, I say, next slide, Margaret, pay attention to the actors, pay attention to the people's actions and not their words. Sometimes during negotiations, someone will start out real low and the person gets offended or they will be reluctant to move forward. Different people negotiate in different ways. There is many, many cases where the plaintiff has asked for $5 million and the first offer is $10,000 and the case gets resolved. Look at what they're doing. pay the same attention you paid during a trial to what's going on to the meeting. Are they leaving? Do they have the right person there? Are they engaged? Let the process play it out. Really, the mediation doesn't end till one side or the other walks out. And you often have to, maybe sometimes too much, test that process. Put them in a position that if they want to walk out, they can walk out. If they're going to, just keep the process going, and at a period of time, you'll decide or find out whether they really have money and they're really serious about resolving the case. I know I'm probably running out of time. Our next one is, and this may be one of the more important, maybe the single most important fact in governing settlements. People talk about the facts of the case, but in my opinion, what really drives the value, what the, I'll say, better, more successful lawyers achieve more money in settlements is because they're willing to try the case. Think about it. If you're in any negotiation for anything, and if the other side knows you are not going to go forward, or you want it less, or you're less than they want it, you are not going to get a maximum result. So it's just a fact. If the other side believes either your client or the lawyer is not willing to try the case, does not have the funding to try the case, is not going to devote the time necessary to try the case, you will not achieve the maximum result. And that's really what I think we owe our clients in every case, is to achieve the maximum result. And that's sort of how we approach these type of cases. And now I'm going to introduce Margaret. I think she goes next. So Margaret made this a lot easier. Margaret tried and appealed and won a landmark nursing home case in Illinois, which allowed us, if we were successful, to not only get whatever verdict we achieve for our client, but to recover the attorney's fees, meaning make the defendant pay the fees, and in addition to that, make the defendant pay the costs. Because one of the things that sometimes held me back in these mediations is, I know to go to trial it may cost $100,000 in out-of-pocket costs, or $200,000, or Pat will tell you it could cost $300,000 or $500,000. And if you're going to eventually get $1 million verdict, that would impact what our client would recover. We don't care. We take the position, we're like insurance companies. We'll spend unlimited funds. But if our client has to pay us back for the costs after the case, that would impact their recovery. So the case that Margaret won, both in the trial court on appeal, I'll take a little credit. I was one of the witnesses on the attorney fee issue. No, but seriously, says that the defendant not only has to pay our costs, our fees, but have to pay our costs. So now we have no limits at all. Now we will maximize every recovery we can for our client, because we have the money to fund the case. And as long as it's not coming out of our client's pockets, ultimately, that empowers us.
Well, Steve just summarized everything I was going to tell you, but so the case is called Growl versus Clare Oaks. It's a 2019 appellate decision. I have it cited in a paper I left at the back, but if anyone wants it, they can email me. The case was a trial court victory for the plaintiffs of $4.1 million. We petitioned the circuit court to award attorney's fees and costs. The novel issue really was that in the past, most of the case law that dealt with attorney's fees was in verdicts where the verdict was nominal and not really fair to calculate a 1/3 contingency fee on, because the work that went into it was more substantial. And so there was a case called Berlocq versus Villa Scalabrine that, until Growl, had kind of set the standard for how to calculate attorney's fees. And the good thing about Berlocq is that in Berlocq, although the verdict was nominal and the attorney fee sought was an hours times rate basis, and I think in Berlocq the verdict was somewhere in the $10,000 range, and the trial court had awarded somewhere in the $80,000 range for fees. and the appellate court affirmed that and basically reasoned that no attorney would take a Nursing Home Care Act case knowing that the possibility of a $10,000 verdict where their fee was 1/3 was going to be the result. But it did leave open the possibility that in the future there may be a case where a plaintiff's lawyer would elect to take a contingency fee. And in Berlocq, the defense had taken the position that the plaintiff's attorneys should be limited to the attorney's fee. And Berlocq basically said it needs to be reasonable and outlined some of the factors from a case called Madelinsky that cites to the rules of professional conduct in determining the appropriateness of attorney's fee. So in Growl, of course, because we got a substantial verdict, we sought a 1/3 fee. And the defense response was, no, you should be limited to the calculation of hours times rate. And you don't keep hours times rates because you're not a defense firm. So, good luck getting your fee. So our response was that we actually do have a method of calculating an hours times rate methodology and fee. And so we said, no, the contingency fee is appropriate. We had some affidavits from folks who had handled these cases before. One of them was actually Pat Salvi's partner, Tara Devine, and another attorney, Mike Mertz, whose firm handles these cases. They said 1/3 appropriate. And then we did do a calculation of hours times rate, which based on our setting of our attorney's fees would have resulted in a higher award for attorney's fees than the contingency fee. So, and then of course, we knew that we would be testing on this case the issue of what costs would be recoverable, because that's always kind of been a gray area in nursing home cases. For those unfamiliar with the Nursing Home Care Act, it says a successful litigant can have their fees and costs paid by the defense. And for years, we had kind of argued, but no one had tested it, that costs, in our opinion, meant litigation costs. So we're talking about things like expert expenses, trial costs, trial graphics, jury consultants, all the things that go into putting together a successful trial. And the defense had said, no, these are costs that are limited, much like the costs in the Code of Civil Procedure, which are limited, basically, we all know it, to jury fees and filing costs and things that are really nominal in the grand scheme of things. So the result at the trial court level was that we got our 1/3 fee and we got our costs, and the appellate court affirmed that. And the appellate court said, we're not saying whether it's appropriate to calculate cases on a go-forward basis on a contingency fee or an hours times rate, but we're saying in this case with this result and based on the evidence, it was appropriate to award a contingency fee. And that's important because there may be cases where an hours times rate fee in the future is more appropriate. But the costs that were awarded in that case were $147,000. And I had, probably to Steve's dismay, I had really gone through my cost ledger and only really put forward costs that I knew couldn't really be questioned by the defense. So I did leave some costs out that they could question because they could say, you guys spent too much money on this, et cetera. But I had an interesting conversation the other day with a defense lawyer about settlement. And it was clear to me based on his comments that he thought that he wanted to do a mediation, but he sort of thought the case was of lower value than I did. And I said, I'm getting the impression that you think this case is a cost of defense case. And if that's the case, then we just shouldn't mediate it. And he said, well, I didn't say it was the cost of defense case. And I said, so are you saying I'm going to win? And he said, I think you probably will win. And I said, well, then the cost of the case just got higher because you realize now we have this case Growl. So at a minimum, you're looking at expenses of $150,000 plus my fee that I elect, whether it's hours or whether it's a contingency fee and whatever award on top of that. So he acknowledged that he understood the case and, that he thought it was worth mediation and that they're well aware of that case and their risks. But just an example of how we can kind of flip the script now with that, because the cost to them, even if we get $1, is a 6-figure cost. And I will turn it over to Kelly and Steve, who are going to talk about some of the common defense tactics at mediation and how to combat them.
Thank you. Hello, everybody. I'm Steve Malman. Steve Levin covered, Steve, a lot of the topics to discuss. But one of the first things he talked about was it's not about feelings. And one of the things we see a lot now is the apology tour. And has anybody had this in a mediation? I'm sure Pat's had it. So the defense comes in and wants to meet your client with their insurance adjuster, and they apologize for the wrongs and the harms to your client. What we have done is we weaponize that. So one of the other things I'll talk about is preparing your client for a mediation. I think it's as important as preparing for a deposition. I tell the client, listen, they're going to come in, they're going to want to meet you, and they're going to apologize, right? It's an apology without remorse. Were they there at the funeral? Did they call after your mother fell and broke her hip? Did they follow up? Did they ever contact you? No. 4 years later, they send a lawyer and an insurance adjuster, and now they're apologizing. That takes the emotion out of your client in a negative way, and they're energized now to say no, to make sure you get the right money on the case, the fair money on the case, and you take out that element of it. It's very effective. Secondly, and Steve talked about this also, is we'll never leave a mediation. Like Steve said, put them in a position where they can walk. If they want to walk and they want to leave and leave it on the table, that's fine. But we'll always be the last ones to stay. I'm not saying you're going to cave in or limit what you're going to do, but at least stay and let them walk. The other thing is, in nursing home cases, everyone knows this, it's very difficult to assess the value of these cases. Part of it's because the good work Margaret and Steve have done on the Growl case and the attorney's fees and expenses. One of the things you can do, which we like to do, is focus group the cases. You can focus group them ahead of time and try to figure out what the value of a case is. Try to figure out what the injuries are. Figure out what your high limit is, what the bottom is. Get a feel for the issues in the case. So going into mediation, you have a better feel for where you should be. We found it very effective. So another thing that we've seen, I think this has been going on for a long time, but kind of surprise issues that come up, predominantly insurance issues, where for the first time you hear there's an aggregate issue. So as Steve talked about, say there's a $10 million policy over this 1 year period, and they're eating into it, and now there's only $7 million or $3 million left, whatever the number is, and now all of a sudden they're telling you have this aggregate issue, we can only pay you so much money. So what you want to do is going in, you want to find out what the issues are, where you are on coverage, what's left on the aggregate. In addition, they have these eroding policies, which we see them a lot in nursing home cases. They're $250,000 or $500,000 or $1 million minus defense costs and fees. You want to know going in what's left on that policy. You need to know what your maximum recovery is, because most of these facilities, they're shell corporations on top of shell corporations. The real estate's owned by one company. Everything else is owned by another company, and the licensee has absolutely nothing but this insurance policy. So you want to know what's there in order to maximize your recovery, and that will help a lot. Can't see anything. So one of the other final things that we see a lot, sometimes when you get to these mediations, you get a lot of defense lawyers fishing around to get your theory. I don't know if there's any defense lawyers in the room, I hope not, but I don't think they always catch on to plaintiff's theories, especially in nursing home cases. I don't think they know where we're going. So you get a lot of fishing for facts. They want to talk about facts a little bit. They don't want to disclose too much, but they want the mediator to relay some facts to them. Lately, we've kind of been avoiding talking in detail about anything that's not apparently obvious. Otherwise, we just get into the numbers, because sometimes they're just fishing and you get these low offers that are worthless, and they only came to try to find out what you knew. So it's not going to benefit anybody for you to go if they're just fishing around. So you just got to be wary of that. And again, the final note, but I think preparing the client's the most important, because like Steve said, they wear them down. We tell all our clients nothing is going to happen If it's a 9 o'clock mediation, it ends at 1:30, nothing happens till 1 o'clock. So just read your phone or eat some crackers, whatever you're gonna do. Same thing with the late ones, nothing happens, but if you prepare them for the wait, I think you'll give yourself a better opportunity to get the best result for your client. Thank you.
So I have some pretty big shoes to fill here behind these three, but I think they pretty much covered it all, and I know we're running behind on time, so I'll be the short part. Obviously, for those of you who want to learn more about nursing home, we're all available at any time. These three have really set good precedents. There's going to be a huge conference in May on nursing home. Steve, I'm sure, is probably running it, if not talking at all of the presentations. And that, I believe, is May 16th here as well. So that's all. The short.
No, I forgot to acknowledge Abby Marshall from our office, who's responsible for the PowerPoints for my talk.
She used all of her legal skills.
Yes.
Steve.
Yeah, thank you all. Very informative, and we appreciate all your input. Does anybody have any questions? Again, we've got a microphone circulating out there. Yeah, okay. Hold on.
Hi, Mr. Malman. You mentioned about leaving, who leaves and when it ends and why it's relevant, which party departs from the mediation or walks away. Can you explain why that is so important? Why you believe it's important that you are the last to leave in the negotiation?
I think it's important you leave the ball in their court. So you've stated your position. And listen, I'm not going to say I haven't stormed out of an occasional mediation. There are some people who might know that under certain circumstances, but generally, if we've got to our number, we're not going to leave. If they want to walk out, and they can walk out and walk away from that number, because that number's gone after they leave. That's the end of it. That's never going to go down from whatever that number is. And we don't want to be the ones, if it's the number we're looking for and it maximizes our settlement and our clients on board with it, we want to make sure we have every opportunity to get it done. There's too many times, and I've experienced this, I'm sure many people have in the room, a little miscommunication can cause a case to go sideways really quickly. So by not leaving and letting them leave, it's in their court, and you've done everything you could to get it resolved for the maximum.